I'm Richard Ross. I'm number 38 in the hot seat. Not in the hot seat, the hot sheet. But I am in the hot seat. And I'm a family law attorney. I'm a certified family law specialist. I've been certified since 2002 by the State Bar in the area of family law. Family law is not, a lot of people will say, is family law trusts and wills? It is not. Family law is dissolution of marriage, dissolution of annulments. It deals with legal separations, child custody and visitation, child support, spousal support, property divisions. We often deal with domestic violence situations, prosecuting and sometimes defending. And we deal with interstate child custody matters as well. Today I'd like to talk about what are some of the pitfalls of self-representation. And there are some. One of the things that has occurred in my practice, and I've seen way too often, is people coming in and telling me that they have orders that they have modified on their own. Let me give you an example. I have had people come in and say that, let's say they had a child support order of $4,000 a month, and they made a decision with the person, their former spouse who they're paying, to change that. Let's say they came up and they made an agreement because one of them moved across town, and they decided in exchange for driving the children, picking them up and dropping them off, instead of paying me $4,000, pay me $3,000 a month. And so they do this for several years. And suddenly, the spouse, let's say 4 years later, there's a difference of $1,000 a month, so let's see, 12,000 times 4, $48,000. And the other person, the receiving spouse, comes and says, you know what? I want you to pay me back that $48,000. And you know what? I would like you to pay me interest on it as well. Now, is that enforceable or not enforceable? Could I have hands here? Do you think that is an enforceable deal that the two of them have done? Okay. The answer is no. It is not enforceable, and that person's going to get $48,000 plus 10% interest, which is legal interest in California. And this would not have been necessary because the solution would have been to come to an attorney such as our firm, and for a very nominal amount of money, we could have prepared a stipulation and order that would have been presented to a court and would have been signed without even a court appearance. And then that would have been valid because then it would have been changed to $3,000 a month plus this deal on moving the children back and forth across town. And this is more common than you think. This has happened. I have one right now where somebody brought in a spousal support order. It was a little more complicated, but the same basic facts. Spouse support is owed in the amount of around $92,000. Is it fair? Absolutely not. But the legislature decided, I think it was about 2002, that courts that were determining that it was unfair, they basically overruled them and said that because mostly it deals with child support, they want to make sure that kids get support. So they made basically a blanket rule that these things are not, in other words, people cannot make deals. When you have court orders, every time that a support amount is due, February, March, April, it's a new judgment every month, and that judgment accrues interest at 10%. So it's very serious when people don't talk to legal professionals for a very nominal amount of money. This would not have happened. Don't let that happen to you. Another situation that I have seen many times is people coming in after the fact. For example, let's talk about the petition. The petition is the initiating document when anyone files for divorce, dissolution of marriage, legal separation, or what we call nullity or annulments, requesting an annulment. The petition has a lot of boxes on it, and those boxes can be very devastating if the boxes are not checked. I'll give you an example of that. And first of all, the petition is an initiating document, and what that means is it gives the court the authority, the power to make orders with regard to the issues that are checked on the box. So if somebody doesn't check the box spousal support, the court in this case can't give them spousal support. If they don't check the box asking for attorney fees, they're not going to get attorney fees. And this happens quite frequently because often you basically have self-represented people and they figure, well, we don't need an attorney, or they're in mediation. Peter Ware does this type of thing. I'm sure he's aware of that. Not every mediation gets completed. And therefore, they may not have checked the box for attorney fees because they're in mediation. And once they fall out of mediation, then they may want, or one of the other spouses proceeds to litigation. And now you have a situation where the person who's making less money wants to get a contribution from the higher wage earner. And what's going to be necessary now is that you're going to have to go back to court, file an amendment, ask the court, first of all, you file a motion to get an amendment to allow to file an amended petition where you're going to check the box asking for attorney fees. And this, again, a very minor thing, but in other words, if I was representing somebody, my fees could not be paid until I was successfully able to get that modification of that petition. After that, we can get fees, but not before that. So maybe $4,000 or $5,000 later, this would not have happened. Simply going to an attorney or a professional who understands all these things, you can have serious problems when in a situation like this as well. The other thing that we are now dealing with at our firm is what we call unbundled services, and that is relatively new. It used to be that when you hired an attorney, you had to hire an attorney for everything. And when I say everything, in other words, while the attorney is representing you, until you release the attorney or the case ends, you're paying for the attorney. We have found, I think Denise was telling me recently, that 10% of the people in California, only 10% have attorneys where both sides are represented now in these legal proceedings in dissolution. And about 20% where one person has an attorney and the other one doesn't. So that leaves 80% of the people who are not receiving legal advice that could be receiving legal advice if they do it with unbundled services. So unbundled services allows us to basically represent somebody in a particular aspect. Perhaps they hire us just to do the custody or the mediation. And then the rest of once we're done with that, we're basically contractually out of the case. They could come back and hire us to do that. They may hire us to do just the paperwork. Now, there are other services that are out there, legal preparation services that would do that. But what we do that's different is that when we meet with somebody, whether we're doing the paperwork or not, because we don't know if they're going to hire us or later need us, we're going to go through their whole case with them. We're going to give them a strategy. We're going to go and tell them this is how you should approach something. And perhaps we should hire a vocational expert. Perhaps we should go out and get somebody to help with regard to forming a parenting plan. And so even though we're not necessarily hired, we're going to give them advice as to how to handle the entire case. And then, of course, we'll go ahead and prepare these, and we'll check the right boxes on these petitions so that these problems don't occur if they decide to represent themselves. Another thing that we also do is that we'll represent sometimes people not as their attorney. So, for example, in a mediation, so if you have a mediation, the person, if somebody comes and talks to us, we might be able to assist them when they go into the mediation as a consulting attorney. And so each time before they have the mediation, they might come to us and they know that they're dealing on this particular day with, let's say, the issue of custody or the issue of support, and we'll go through it, give them the information, what the law is, so that when they go into the mediation, they can have as much knowledge and make informed decisions. Because in mediation, you can decide anything you want, but at least if you have the informed decisions, that's important, and that's what we're attempting to do, to reach more people and be able to help them in this way. Richard Ross Associates is a full litigation firm as well. We handle cases basically anywhere in California, mostly in Ventura, Los Angeles counties, because we're on the border. I just recently finished a 7-day trial, though, in Santa Barbara County, wonderful court, and enjoyed that. We won, and that was a really tough, but I would like to do more Santa Barbara cases, and we were up in Redwood City up there in San Francisco area as well. I think we're out of time. Is there any questions that I can ask, or answer, I should say? All right. Well, thank you very much, everyone, for your time.
Thank you, Richard. And Richard and Denise, they are absolutely wonderful at what they do, and we really appreciate all that information. Thank you so much.